Welcome back for another deep dive. Looks like our listeners have been sending in some fascinating legal excerpts. A lot of interest this time around. Anticipatory repudiation and contract breaches.
Yeah, it's one of those areas of contract law that can really trip people up. Because it's about looking at a contract not just as like a document, but as a series of actions and expectations playing out over time.
Right. We're not just talking about a breach that's already happened. We're talking about situations where one party is essentially waving a big red flag saying, nope, not going to honor my end of the deal.
Yeah.
And they're making that crystal clear, like way before the deadline even arrives.
Exactly. And the law recognizes that being left in limbo like that can put the innocent party at a real disadvantage.
It's like that old case Hoster v. de la Tour back in 1853. Really set the stage for how we think about anticipatory repudiation. I mean, picture this. A courier gets hired for a grand European trip, everything's set, and then boom, trip's canceled before they even leave the dock.
And that case, Hoster, was a game changer because the prevailing thought back then was, hey, you can't sue for breach of contract until the actual performance date is passed.
So it was like a no harm, no foul kind of deal until the deadline actually hit.
Exactly. But Lord Campbell, in his ruling on Hoster v. de la Tour, he recognized the very real harm that can be caused by just being left hanging. He argued, forcing the courier to just wait around, potentially missing other opportunities, it'd be both impractical and unjust.
It's like being stuck in legal purgatory.
Yeah. And so the court's decision basically said, when one party very clearly renounces the agreement, the other party is not obligated to just twiddle their thumbs and wait for the inevitable breach. They can take action.
So Hoster v. de la Tour, big takeaway, is that the law recognizes the potential harm in waiting for a breach to happen and allows for immediate action, a lawsuit, in the face of a clear renunciation.
Really marked a shift from just looking at the strict letter of the contract to considering the spirit of the agreement and the impact of uncertainty on the parties involved.
Makes you wonder, though, how do you actually prove clear renunciation? Like, where's the line between I'm not honoring this deal and maybe just a really, really tough negotiation tactic?
And you've hit on a really critical point because distinguishing a genuine repudiation from, say, a request for modification to the contract terms, that's where things get really interesting. Because over the years, there have been so many cases that have helped refine what exactly constitutes that clear and unequivocal intent to breach.
It's not just firing off a few heated emails or casually saying, hey, we should renegotiate this.
Right.
There has to be more to it than that.
Exactly.
So to illustrate this, I think it's time we delved into a case that really highlights this very distinction. One that involves a real estate deal gone sour, a proposed asphalt plant, and some, shall we say, interesting zoning regulations.
So this case, Truman Flat & Sons Kampiji Schupf, it was decided in Illinois back in 1992, and it's a perfect example of this whole repudiation issue. We've got Truman Flat. They're all set to sell a chunk of land to the Schupfs, who have big plans to build an asphalt plant. But then, surprise, zoning changes come into play, throwing a real wrench in their plans.
Ah, the classic recipe for a contract dispute. So did the Schupfs just try to back out of the deal altogether?
Not quite. They reached out to Truman Flat, and they basically said, look, with these new zoning rules, our project just got a whole lot more complicated and expensive. We need to adjust the price. They asked for a lower purchase price to offset those unforeseen zoning costs.
Seems like a reasonable request, right? Trying to salvage the deal, not just ditch it entirely. Did the court see it that way?
They did. The court ultimately sided with the Schupfs on this one. They concluded that, yeah, the Schupfs' request for a price reduction, it was pretty strongly worded, sure. But it didn't actually cross the line into a clear and unequivocal intent to breach the contract.
So just asking for a modification, even if it's because something unexpected popped up, doesn't automatically mean you're repudiating the whole deal.
Exactly. And this case really highlights that. Truman Flat shows us that simply asking for a change, even a significant one, isn't the same as throwing up your hands and saying, I'm out of here.
Okay, that makes sense. But what about situations where it's not necessarily what a party is saying, but what they're doing that makes it pretty clear they're backing out?
You're talking about repudiation by impossibility now.
Yeah.
And there's a classic example that plays out in, of all things, the world of racehorse breeding contracts.
Oh, now you've got my attention. Tell me more about this equine legal drama.
All right, so in Taylor v. Johnson, a 1965 case, we have a Mr. Taylor who contracts with Mr. Johnston to breed his mares with, get this, a prize-winning stallion. Sounds straightforward, right?
Sounds like a pretty valuable stallion.
You bet. But here's the catch. Before breeding season even rolls around, Johnston goes and sells the stallion to someone else.
Oh, no, he didn't. That's cold. That seems like a pretty clear breach to me. He knew he couldn't uphold his end of the deal after that.
Exactly. And the court agreed. Even though Johnston never explicitly said, "Sorry, Taylor, not breeding your horses," his actions, selling off that prize stallion, made it physically impossible for him to fulfill his obligation.
It's a classic case of actions speak louder than words, legally speaking.
You got it. And Taylor v. Johnston is a great example of how you don't always need a blatant statement of refusal. Sometimes the circumstances themselves are enough to demonstrate repudiation.
Okay, so let's say we've established a clear repudiation. One party's made it abundantly clear they're not holding up their end of the bargain. Does that mean the wrong party just has to sit back and watch the potential damages pile up?
Not necessarily. That's where the duty to mitigate enters the picture. This principle basically says, hey, you can't just sit back and let the losses accumulate if there are reasonable steps you could be taking to minimize the harm.
It's like the legal world saying, don't just watch the ship sink, grab a lifeboat. But what does that actually look like when it comes to contract breaches?
It means the non-breaching party has a responsibility to take commercially reasonable actions to try and reduce those losses. So going back to our courier example, they couldn't just sit around for months hoping the other party has a change of heart. They'd be expected to look for other employment to mitigate their damages.
So it's about taking proactive steps to lessen the blow, not just letting the situation get worse. Makes sense. But how do you define commercially reasonable actions? That seems like another one of those legal gray areas ripe for debate.
Oh, absolutely. And that's exactly where a case like Cosden Oil and Chemical Co. the Carlo Helm Acting Gesellschaft comes in. It tackles this very issue, and it all unfolds against the backdrop of the Iranian Revolution, no less.
Okay, now that's a story I need to hear. Set the scene for us. Who are the key players in Cosden Oil, and what's the contractual dispute at the heart of it all? Okay, so picture this. We've got Cosden Oil, a company based in Texas. They've agreed to sell a whole lot of polystyrene to Helm, a German company. And then, boom, the Iranian Revolution throws global markets into complete chaos.
Talk about bad timing, right? And Cosden Oil, facing all this market instability, decides to cancel those polystyrene orders.
I bet Helm was not thrilled about that.
Not thrilled at all. They were left high and dry, wondering where their polystyrene went. So, naturally, a lawsuit ensued.
Of course. So what was the big legal question in this whole Cosden Oil debacle?
The crux of the matter was this. When exactly do you measure the damages? Do you look at the moment Cosden Oil made that phone call saying we're backing out? Or do you look at the date when the polystyrene was actually supposed to be delivered? Because, especially in a volatile market like that, those two dates could mean a huge difference in price.
Right, and a huge difference in the amount of damages awarded.
Exactly.
So it's like trying to hit a moving target. What did the court decide in this when-to-measure dilemma?
Well, the court in Cosden Oil, they took a middle-of-the-road approach. They said, nope, not going with either extreme. Neither the repudiation date nor the original performance date was the right answer. Instead, they landed on this idea of a commercially reasonable time after the repudiation.
Ah, yes, the ever-elusive, commercially reasonable time. It seems like that phrase pops up everywhere in contract law. So what does it actually mean in practical terms? How do you pin down what's commercially reasonable?
It boils down to this. Helm, as the non-breaching party, they still have that duty to mitigate, right? But they have some leeway in how long it takes them to react to that breach. The court gets that scrambling to find a new supplier, renegotiating a deal in the middle of a global crisis. Those things don't happen overnight.
So it's not about saying, well, you should have magically solved this problem the second Cosden Oil backed out. It's about figuring out a sensible time frame for minimizing those losses, given the circumstances.
Exactly. Cosden Oil really underscores that balance that the law tries to strike. You want certainty, predictability in contracts, but you also need some room for flexibility, for fairness, when the unexpected inevitably happens.
And as we've seen today, the unexpected happens a lot in the legal world.
You can say that again?
We've journeyed from canceled courier trips to racehorse shenanigans to polystyrene shortages amidst a revolution. Looking back on all these cases, what are some of the big takeaways, the recurring themes we should keep in mind?
One that stands out is the importance of good faith. Contracts, they're legally binding, sure, but courts are generally more understanding if a party honestly believed, even if they were mistaken, that they were acting within their rights when that breach occurred.
So it's not enough to just plead ignorance and say, I didn't know or I misunderstood. You've got to show you genuinely believed you were following the rules of the game.
Precisely. And a big part of demonstrating good faith is communication, clear communication. That's why having a well-drafted contract is so crucial. You want something that spells out each party's rights, responsibilities, no room for ambiguity.
It's like they say, an ounce of prevention is worth a pound of cure.
Couldn't agree more. Clarity up front can prevent a whole lot of legal headaches down the line.
Absolutely. Well, on that note of legal wisdom, I think it's time to wrap up this deep dive into the world of anticipatory repudiation. We've explored the very definition, dug into the nuances of clear and unequivocal intent, and navigated the complexities of installment contracts. And we've learned, sometimes, it's not just what you say, but what you do or don't do that can land you in hot water. Thanks for joining us on this legal adventure. Until next time, stay curious and maybe brush up on your contract law just in case.